I would rather spend my jail time in Kentucky. At least I could smoke in jail. The vapes.
I have your.
Okay. Mr. Saylor, tell me what you think is happening today, sir.
Taking a plea, like, I still don't understand the plea because it didn't happen that way. I didn't use force because when I, walked by her car, she caught my eye because she was wearing bra, the bikini top and bottom. And I opened out the door, touched her butt, but I didn't pull down her shorts or put my hands up under her shorts. But I take the plea if it get me out of here faster. They could say whatever they want to, as long as I know the truth. Because my biggest thing is drugs. I love drugs, and I love my gun. When my gun got taken away in Kentucky, I lost my mind.
Okay, sounds like you're saying you understand what you're doing. You understand that you're pleading guilty to a felony sex offense involving force. Do you understand that?
Basically, kinda.
Okay, it sounds like you were denying the force part there to me. Do you understand that you're pleading guilty to a fourth-degree felony, which will be with you for the rest of your life, and you'll be required to register as a sex offender for how long on this?
15.
It's at tier 1, up to 15 years, Your Honor.
Okay, could be 10, could be 15, but it's up to 15 years.
Whatever, to give back home to my family, whatever to see my family case. My mom and my dad loves me, and I got to be there for them because they getting old.
Okay, here's what I need to make sure of, is that you understand what you're doing.
Not really,
Okay,
because sometimes I black out and I don't know what I'm doing. Like, I didn't even know what I did until they told me when I got to the jail that day. And it
Okay.
was on my brother's birthday.
He's trying to see if you know what you're doing today as far as taking a plea instead of sitting in the trial.
Oh, okay, yeah, I understand what's going on today.
tell me what's going on today.
Taking a plea instead of taking it to trial.
Right, that's right. And that means you admit to doing this.
Yes.
Okay, and you admit to not only touching, which would be sexual imposition, you admit to touching by force, which is gross sexual imposition.
I didn't admit to that, but I admit to the other one. They could say that to get me out of here today.
Well, we can have a trial too.
I don't want to have a trial because it'd be less time more time in jail.
Not necessarily. You could go to prison for 18 months on this charge. If you're found guilty of this charge, you could go to prison for 18 months. Do you understand that?
Yes, sir.
Okay.
Do my jail time counts too?
Yeah, your jail time counts too, but I want to make sure you understand that you could go to jail, you could go to prison for 18 months, and you're pleading guilty to something that you say you didn't do. So there's a little bit of a discrepancy there. Now, if you've talked to your attorney and you feel that the act you committed was done with force, then you understand what's going on. But if you're standing here and denying any force to me, I have a problem with that.
Yes, sir.
Yes, what? You understand what I'm saying?
I basically understand what you're saying in some kind of way, but in other ways I don't really know what's going on because I ain't on the right meds like I'm supposed to be on. And when I was a kid, they put me in foster care and I got raped by a full-grown man and full-grown women when I was a kid.
Okay. That's a traumatic experience that I assume you discussed with the people who, at Summit, who evaluated you.
I want to talk about that to them, cause they asked if somebody in my family commit suicide, and I stopped talking to them. I stopped seeing that lady, Cammy, and she came and done another person came and done another interview, and I didn't understand. They just asked if we knew something about trial and stuff. But the first doctor, Dr. O'Donnell, was asking me if I had anybody in my family commit suicide and stuff. Yes, but I didn't tell her that. And when I don't get my way or whatever, if you look at my arms, you can see I'm a big cutter.
Okay. Mr. Statement, why is he pleading guilty to this offense?
Your Honor, my client is adamant that he does not want to go to trial in this matter. And that's the discussion we've been having.
But he's denying
the force aspect, yes.
Okay.
And my recommendation would be set it for a bench trial.
Well, this doesn't appear to be your recommendation.
But my client is adamant he does not want to go to trial. He wants to accept a plea. Is that right?
Yes, so to get up out of here and get a treatment program, because I am very addicted to drugs.
Okay. Pleading guilty to something doesn't guarantee you'll get a treatment program. I'm more hung up on this fact that you deny that there was force involved. Now, if you have a trial and it turns out that it was, you're not going to be punished more just because you had a trial. If you plead guilty and you're saying, I accept responsibility, I did this, I did it by force, which makes it a felony, that's fine too. But you're saying two different things. You're saying, I touched her, I didn't use any force, and I just want to get this over with. But that's not going to get it, because you're going to regret it in the future, if that's the case.
I take it to trial then,
Okay.
because I still don't understand what's going on.
Okay, well, you seem to have a good understanding of what's going on. The problem is you're saying some things that are contradictory, meaning you're saying one thing and then you're saying another that's the exact opposite. So set it for trial.
Very good.
Bench trial.
Your Honor, hold on, but we still have the competency issue. Are we stipulating to the competency report? I thought, yeah, I just want to make sure we've done that first.
Okay, let's talk about that. You have been determined to be competent to stand trial, meaning you understand the charges against you and you understand enough to assist your attorney in defending you in this case. You had two choices. You can agree, yes, I'm competent, or you can say, no, I'm not, and your attorney can request a second opinion. The second opinion may very well say the same thing because you seem to understand what you're doing. Your attorney is saying, we agree Mr. Saylor is competent. He understands what's going on, and he understands enough to help me defend him. Do you understand that?
Yes, Your Honor.
Okay. Do you believe that's true?
Yes.
Okay. Then I'm going to make a finding that he's competent based upon Dr. Nick Stang's report. She's a very qualified psychologist, and she's made a determination that you've been at Summit long enough. They helped you understand how to participate in a trial. So we're going to go to trial in the case, and I don't know what the outcome will be, but it's not going to be any worse. You're not going to be punished for exercising your right to have a trial.
And my jail time accounts into my sentencing too?
You already asked me that. Do you remember asking me that a few minutes ago?
No.
Okay. Yes. Yeah, for all the time that you serve in jail on this case, you get credit for that. If you're found guilty and you're sentenced, you'll get credit for that as a part of the sentence.
Either way, if I take it to trial or take a plea, it's 18 months. I got to spend
That's
in
the
jail.
maximum you could get. It doesn't mean you'll get 18 months. I just want to make sure you understand you could get 18 months. Either way. Either way. Do you understand that?
Oh, yes, so I don't really want this on my record because I got enough felonies on my record, and I don't want this on my record.
Okay, well, I don't blame you. If you're found guilty, it will be on your record. And if you're found not guilty, it won't be on your record.
Because Kentucky, they dismissed a handgun case, and can Kentucky pick up my handgun case and send me back over to Kentucky? Because I would have spent my jail time in Kentucky. At least I could smoke in jail. The vapes.
You know why you can smoke in jail in Kentucky? Because tobacco's their main crop. Okay.
Hell, a pot is that us main crop.
Well, it may be.
I'm a big pothead.
I can't advise you on Kentucky. If they dismiss the charge, it's dismissed. That's where it stands. I can't predict the future. And this trial is not going to affect what they do, to my knowledge.
Okay.
Ms. Hyatt, how many witnesses do you have?
I will have approximately, let's get to that, I'm sorry.
Did you say 4?
I would say 3 to 4.
Okay.
I don't anticipate any for the defense, Your Honor.
Okay. All right, so this is a one-day trial at the most, maybe a half day.
Mm-hmm.
Okay.
My mom and my dad was there. They was calling my name, but they didn't know where I was at. They thought I was in the bushes taking a shit. But I went to the bathroom at the store.
All right, hold on, don't tell them things.
Are we waiving jury, Your Honor?
Or
are we having a jury trial?
We've got to do that. There's 2 types of trials you can have. One is a trial to me. The other is a trial to a jury of 12 people. You have a right to have either. If you have a jury trial, all 12 people on that jury have to agree you've been proven guilty beyond a reasonable doubt. All 12 people have to decide that before you can be convicted. If you have a trial to the judge, it's just one person who makes that decision. In this case, that would be me. So if you want a jury trial, you can have a jury trial too.
I take a bench trial.
Okay.
I don't got no clothes I could wear to a trial.
Oh, you can have clothes. We can get you clothes. Mr. Staten, have you talked to him about the difference in a jury trial?
We did, Your Honor, briefly, but as I said, he was adamant he did not at that time want to do a trial of either type.
Okay, why don't you talk to him a few minutes back there?
If I could.
He may be better off with the jury. I don't know, but at least
Sure.
I want him to understand the difference.
Absolutely.
Okay, thank you. All right, you've had some time to speak with Mr. Saylor. Do you prefer a jury trial or a bench trial?
A bench trial, Your Honor.
Okay. All right, sir, you have a right to a trial by a jury of 12 people. And a jury trial may be better for you because some jurors might not find this to be extremely serious, but if they follow the law and the elements are met, they also can convict you. But it would take all 12 of those jurors to agree before you could be convicted. If you tried to me, it's just one person who makes the decision. Do you understand that?
Yes, so
Okay.
and that one come I pick you cause you might understand my mental health issue and stuff like that.
Well, that's a good point.
Like I got color vision. I can remember some parts about the accident, but I can't remember all of it. I can remember walking by, stopping, lit up my cigarette, and I saw.
Okay, but don't need to tell him right now.
Okay,
So you want to try it just to me.
yeah,
Okay, you understand that.
yeah,
Okay, seems like that's your desire. It's what you want to do.
yeah.
Okay. All right, set it for a bench trial then.
We have a to-be tried date, Your Honor, if he's found competent today of November 21st, just so you know.
Okay, what are his living arrangements?
That's, I think, one of the issues, because his family's not here.
And they're out of state.
Okay, we will make time for a half-day bench trial. If you have any trouble setting this with Bethany, check with me, because we can set it on a Friday, which we normally don't, unless the case it goes Thursday, Friday, but we could do that. So we'll figure this out.
Do y'all want my mom's, my sister's phone number?
I'm sorry,
Y'all want my mom's, my sister's phone number?
for what?
Well,
I'll call him.
okay.
I'll call him, Kevin.
To let them know what's happening.
Okay, yeah, your attorney will take care of that for you.
Okay.
I got him. 256-298-2941.
Yeah, and my sister's phone number is 256-977-3657.
That's the sister. Okay.
Yeah, Jennifer.
All right. Well, we're going to set this as soon as we can, as soon as the judge can. I got it. Thank you, Your Honor.
Yes, sir.
What happens when a competency hearing becomes one of the most unfiltered confessions ever caught on camera? In an Ohio courtroom, Mr. Saylor arrived facing a gross sexual imposition charge, a fourth-degree felony. But before the case could even move forward, the judge had to answer a fundamental question. Did this man truly understand what he was about to agree to? The answer, it turned out, was complicated. Saylor openly described the incident, admitting he touched the victim, but flatly denying the force element that elevated the charge to a felony. In the same breath, he said he'd take the plea anyway, just to get out faster. The judge didn't let that slide. He stopped the proceedings cold, pointing out the obvious contradiction. You cannot plead guilty to something you're simultaneously denying. What followed was a raw, an unscripted window into a man battling addiction, blackouts, untreated mental health conditions, and a traumatic past that had clearly never been fully addressed. He talked about his love of drugs and guns. He mentioned wanting to serve time in Kentucky so he could vape. He cited color vision and memory gaps. He even started reciting his family's phone numbers unprompted. Through it all, the judge remained patient, methodically walking Saylor through his rights, explaining the difference between a bench trial and a jury trial, and ultimately finding him competent based on a qualified psychologist's evaluation. The plea was rejected. A bench trial was set, because in that courtroom, the judge understood something critical. A guilty plea means nothing if the person entering it doesn't truly understand what they are admitting to. Competency isn't just a formality, it's the foundation of justice itself. If you found this case as eye-opening as we did, hit that like button, drop your thoughts in the comments, and subscribe for more real courtroom breakdowns. Because justice never gets old.